kindly be seated. We will start shortly. arbitral awards. The judgments raise policy and practical concerns and the risks of opening up arbitral awards to modification rather than annulment, and the resultant unpredictability that may ensue, and potentially the impact on India's reputation as an arbitration-friendly jurisdiction. I request our esteemed speakers to join us on the dais. Honorable Shri Justice Sachin S. Magadum, Honorable Judge, High Court of Karnataka, brings over 2 decades of experience in civil, criminal, and constitutional matters. Justice Magadum practiced at courts in Belgavi, Bengaluru, and Dharwad before his elevation to the bench. During his career at the bar, Justice Magadum represented clients before various tribunals and statutory bodies, including the Karnataka Appellate Tribunal and State Consumer Disputes Redressal Commission. He also served as standing counsel for key public institutions such as NHAI, KIMS, and contributed to several other matters of public importance. Welcome, Justice Magadum. Honorable Shri Justice Vineet Kothari, former Acting Chief Justice, Gujarat High Court, was elevated to the bench in 2005 and retired in 2021. Justice Kothari now practices in the Constitutional Courts of India with his main practice areas in domestic tax law, international tax and service law, corporate and insolvency laws, and property and family matters. His keen and active involvement in alternative dispute resolution encompasses commercial and contractual dispute resolution through various domestic and international arbitration and mediation institutions. He is empaneled as an arbitrator with most of the high courts in India annexed to the centers and is on the board of private arbitration and mediation centers like the Nani Palkiwala Arbitration Center. Thank you for joining us, Justice Kothari. Ms. N.V. Bhavani, an alumnus of the National Law School, was appointed as an additional district and sessions judge in 2015 and has worked at Mangalore, Bellary, Bangalore as an additional district and sessions judge. Ms. Bhavani was designated as a principal and district and sessions judge at Chikbalapur in 2023 and now serves as the Principal Secretary to the Government, Department of Law, Justice and Human Rights. Thank you for joining us, ma'am. Mr. Prashant VG is a partner at JSA Bangalore and has been specializing in litigation and arbitration since his graduation in 2005. He has dealt with disputes related to a wide range of legal subjects like company matters, contract law, property and real estate, partnership, trust, intellectual property, and other related matters. Thank you for joining us, sir. Mr. Shamir is a partner at Tri-Legal and heads its dispute resolution practice. His wide experience in dispute resolution extends to commercial litigation, arbitration, real estate litigation, labor, employment, and criminal disputes. He regularly appears before various fora and provides end-to-end representation and advice to clients in different contentious situations. He has successfully defended and prosecuted arbitrations concerning breach and enforcement of contracts, construction disputes relating to large infrastructure and public utility projects. Thank you for joining us today, Shamir. With that, I hand over to the panelists for this discussion.
A very good evening to all. A very distinguished guest on the dais, senior lawyers practicing exclusively on the arbitration side, young advocates, arbitrators, and all officials connected to this academy. I was apprised and informed that Justice Kothari Saab has intensely prepared to address this gathering. So I immediately got relaxed. And I've already put a caveat to him indicating that my opening remarks will be very brief, so be prepared to handle the audience. And since it's a closure session, I don't want to test your patience. And decoding part will be done by Kothari Saab and the experts in the panel. I'm a Section 11 judge. It's a very nascent stage. I'm not going to apply my mind. I can't have a deep dive. All that I have to see is there is a clause. And all complex issues that are thrown at me, and they were thrown at me only on 8 Fridays. Because I was given an additional roster and I handled these CMP matters only on Fridays. So don't expect too much from me. Decoding will be done by them. I will deliberate, and unilaterally I have decided that I am a part of the audience and I am a very good listener. These 2 judgments, I think, really mark 2 pivotal turning points in Indian arbitration jurisprudence. Cox and King's restructures the very doctrine of non-signatories and composite transactions. And the next judgment which we are going to deliberate, Gayatri, Balasamy, I think this will take us a long way. There's a hope now. 34 application was very tightly insulated proceedings. I'm yet to come across some experts to really elaborate and tell me that how really 34-1 application operates once the award is passed. Now there is a narrow window. Now there is some scope. While Cox and King's judgment really has reworked the doctrine of non-signatories, Balasamy really brings in some hope, and there is scope for judicial review in a very limited manner. While both these judgments, according to me, create a very harmonized framework balancing party autonomy, judicial restraint, efficiency, and commercial practicality. I think Cox and Kings can be deliberated before this audience by the experts, largely by quoting illustrations. When a non-signatory can be forced to face arbitration, when a non-signatory entity can really assert and say that I am an interested party, I have to be heard, any award that would be passed would have a direct impact on me. And when a non-signatory entity may take a defense saying that I have nothing to do with this transaction, I am not party, I am not remotely connected. The Honorable Apex Court really summed up beautifully saying that 2 ingredients are essential to examine the doctrine of non-signatory and composite transaction. One is intention. The other component, which is a must and essential, is your active participation, which can be gathered from what you do from your conduct. So Cox and Kings really redefined, and GOC is now held to be valid in India, if I'm correct. Then the next interesting part, and on illustration side, I think a few I can quote, which can be further elaborated by experts. One of the illustration to the younger minds would be that when a subsidiary company signs an agreement, but if a parent company would step in and start negotiating the pricing, supervising the project, issues performance directions, that's where you can really rope in, bring in a parent company, despite not being a party to the agreement. Then when you cannot really bring in a subsidiary or a group of a company member, mainly because it is linked to a corporate uh, entity is where A company signs a contract with arbitration, company B is a sister concern, with absolutely no negotiation involvement, no performance role. In such cases, you can't rope in or you cannot insist and bring in that entity to be subjected to arbitration proceedings. There are many more illustrations, probably my experts will delve upon it. And now coming to this landmark judgment, Gayatri Balasamy judgment, a very landmark judgment. Honorable Apex Court really lays emphasis on severability of awards under Section 34(2)(a), Roman 4. Apex Court, while rendering this landmark judgment, held that the courts may set aside only those parts of an award that go beyond arbitrable issues. Then it also further said that this power is clarifactory and inherent, and the limits are that severance is not permitted where valid and invalid portions are intertwined or factual legal findings overlap inseparably. Now, distinction between modification and setting aside, this is also dealt by Honorable Apex Court. What is permissible is only modification. And the precondition for modification is award should be separable, rather. Severability, unless severability is not established, modification is not permissible. So Apex Court held that limited power to modify awards under Section 34 only relates to computational errors, clerical errors, typographical mistakes, manifest mechanical errors. Illustrations, I would quote 2 or 3 illustrations where award component has contractual damages, say let us 50 lakhs, and a 10 lakh penalty for criminal intimidation, which is not arbitrable. So where it is found to be severable, that part can be dealt. Part 2 can be definitely dealt upon. 34 court can interfere and modify that part of the award. Now, there may be computational modification which can be allowed, where award calculates 12% per annum as a 24%. That can be rectified. Court may correct it. Then typographical error corrections, where 5 lakhs instead of 50 lakhs, there is error. That falls under part 2. That can be rectified. Where modification cannot be allowed, where party challenges damages as excessive and asks court to reduce them. That is virtually touching upon the findings, which is not permissible under arbitration regime. That is not permissible. Then rectifying an incorrect interest period, that can be done. 2020 agreement, award says that you are entitled for interest from 2010. That is an error, that can be rectified. When the entire award cannot be severed, then the 34 court has to either confirm the award or has to set aside the award. Now, how these 2 decisions, one in Cox and King and Gayatri, would work. The principles underlying in Cox and Kings is who is bound to arbitrate. For that, intention has to be gathered. It has to be examined. In Gayatri Balasamy, what courts may do with the award. There is a small window which is now provided under the latest landmark judgment. What are the core doctrines under Cox and Kings and Gayatri Balasamy? Under Cox and Kings, it is an intention-based group of companies, while Gayatri Balasamy deals with severability plus limited modification. Whether there are addressed by in both the judgments, of course. The Cox and Kings now discourages inclusion of non-signatories if there is no intention and if there is no active participation. While under Gayatri Balasamy, 34 court cannot annul the entire award. There is a limited scope. What are the takeaways from these 2 judgments? Cox and Kings makes consent central. Non-signatories join arbitration only with proven intention. Now, arbitration exit gate is also strengthened under the latest judgment under Gayatri. Gayatri Balasamy gives courts tools to only prove invalid parts, preserve valid portions, correct errors mechanically, avoid unnecessary re-arbitration. So with these opening remarks, I would leave it to the experts to dwell upon it, and since litigants are now assured by these two judgments that they'll be protected against redundant re-arbitration, wholesale annulment of good findings, multi-layer cycles of challenges and demands, let the experts deep dive and enlighten you. I'm deeply honored for being invited to be part of this intellectual feast. I'm also looking forward, ready to absorb optimum along with you. And I'm really grateful to be invited here. I hope that I too carry a lot of insight into these two judgments. With this, thank you one and all. Jai Hind, Jai Karnataka.
Thank you, Brother Sachin Magnum, to have said so many good words about me. You are Section 11 judge. I have been, but now I'm the person who faces mostly bullets, which they were talking in the other hall. For the last 4 years, I've been working as arbitrator. So if I come up to your expectation, at least I can expect an assignment under Section 11 from you now. Friends, these two constitutional judgments, which all of you are almost aware of everything, are basically common sense judgments. Though they are coming from Constitution Bench of the Honorable Supreme Court, one in 24 and other is 25. So let me discuss a brief about them in sequence of that only. Why they are common sense judgments, and from these judgments, what I gather is that arbitration scenario in this country is still evolving. It has not matured enough. Though we have 1940 Act substituted by 1996 Act, but after even 29, 30 years of 1996 Act, I feel that law is still evolving, and I think if a detailed debate about arbitration law is made in such conferences, some more amendments may be required in this law to make it really a good ADR system, which we all know is very useful and necessary from the litigation analysis in the courts right from top to bottom, where the decades can pass, if not the years, before one finally gets even a adjudicated order or decree. Cox and Kings talks of making non-signatories as party and bound by the arbitral award. If you recollect representative suits in Order 1 Rule 8 CPC, the concept is like that only. If somebody representing your interest is in the court to take an adjudication, you may not be before the court, but the decree will bind you. Something like this with the evolution of the corporate culture in the worldwide and even in the country. This pronouncement, I think, is ice-breaking. Section 7 only talked of written agreement, signatories, party autonomy, all this narrow kind of thing. This judgment, through judicial interpretive process, expands the horizons. And thanks to the Constitution Bench, Justice Deva Chandrachud, Chief Justice of India, as Lordship then was, gave a very, very elaborate discussion of the corporate principles of group of companies and why this became necessary for Constitution Bench to expand the horizon of the arbitration from the narrow compass of Section 7 to outside that also, not to allow the litigation or adjudication to scatter or spill beyond a limit. They always wanted that whatever adjudication takes place, even in the ADR forum of arbitral tribunal, should ultimately put the dispute to rest. And whoever is interested in that dispute is either gaining or losing from that adjudication should be either heard by the tribunal or in his representative capacity, someone is already represented, then it or he or she will be bound by that arbitral award. The 12 ratios which comes from the Constitution Bench in Cox and Kings, 24-4 SEC page 1, are beautifully given in the head note of SEC itself. And I'll one by one, just briefly, I'll not take more than 10 minutes, that's the time allotted to me by the panel. The concept of parties in section 2(1)(h) and 7 has to be read to including both signatories and non-signatories parties. Now, this inclusion of non-signatory parties is a judge-made law. So it expands the horizon to that extent. The second aspect, which Brother Sachin also pointed out, is the conduct of the parties. If the holding company, like he said, is supervising the arbitration proceedings of a subsidiary company and is likely to be affected by the contract which is entered into by the subsidiary company with a third party, then even holding company will be bound by that award. So, the conduct of non-signatory parties could be an indicator to their consent. Actual consent, signature may not be there, but conduct will be shown. And who will decide this joinder or the necessity of joinder? The arbitration tribunal, not Section 11 court. Unfortunately, the experience shows that Section 11 is taking long times in our courts because the courts are going beyond Section 11's scope itself. In my understanding, Section 11 is essentially an administrative job. Way back, Justice C.K. Thakkar said in one of the first judgments that Section 11 is an administrative job, but he was in minority. But I feel that Section 11 coming to the scheme of the law, if you see, after Section 7, 8, 9, is because the people come to courts because parties cannot settle on the name of arbitrator, and the court has the data and information about the experts or arbitrators who can be or who should be appointed as arbitrator in that particular dispute. So there you need not decide the issues like mixed question of facts of limitation. The only thing to be seen is existence of a valid arbitration clause or agreement. That is the need of the Section 11. Beyond that, everything is, I think, verbose. So perhaps either the law needs to be amended or the judge-made law itself has to fall in line. And that is why these kind of controversies happen, and then again Constitutional Bench has to sit and decide on the overall scope of the thing. The requirement of written agreement, arbitration agreement Section 7 does not exclude the possibility of binding non-signatory parties, goes with ratio number 1. Under Arbitration Act, concept of party is distinct and different from the concept of person claiming through or under a party to arbitration agreement, Section 45. So now that concept is brought in, and any person claiming through or under a party to the agreement can also be bound. So that is what 45 scope has now been expanded to be included in Section 7 and 11 scope. That is why this Constitutional Bench judgment expands the horizons in my understanding. The principles of alter ego or piercing through the corporate veil cannot be the basis of the application of group of companies. That's a principle which has its own sanctity. But if the court feels in the interest of justice that corporate veil deserves to be lifted, the court, giving its own reasons and findings for doing so, can lift that also. And that is what lies in the background of these judgments. The group of companies doctrine has an independent existence as principle of law, which stems from harmonious reading of 2(1)(h) and Section 7. Very well. To apply the group of companies doctrine, the courts or tribunals, as the case may be, have to consider all the cumulative factors laid down in discovery enterprise case. Resultantly, the principle of single economic unit cannot be the sole basis of invoking the group of companies doctrine. So merely because it is a single one economic unit, only that signatory will be bound needs to be looked into, while the interest or conduct of the parties who is a non-signatory to the agreement is also looked into. The principle or the jurisprudence behind that also remains the same, not to allow the litigation to scatter beyond the reasonable limit. The person claiming through or under can only assert a right in derivative capacity. So if somebody or some entity is deriving some interest or benefit out of that adjudication, he or it can also be made a party to that, even if he is non-signatory. So this concept of being non-signatory is a judge-made law expanded by this judgment read into Section 7. That is what I believe is the decoding of this judgment. This judgment discusses two eras, pre-chloro controls, where they laid the foundation perhaps for this judgment in 2013, to the extent that it traced the group of companies doctrine to the phrase claiming through or under is erroneous and against well-established principles of contract law and corporate law. Otherwise, what we generally understand in corporate law is that company is a separate entity, a juristic person, and it has own limits. But these judgments, particularly when you are dealing with a scenario of ADR, arbitration, which is supposed to be providing an efficient and effective substitute of the litigation channels in our system, then these principles have to be evolved for achieving the objective of the solution to the dispute or adjudication of the dispute. And the court said, at the referral stage, the referral court should leave it for the arbitration tribunal to decide whether the non-signatory is bound by the arbitration agreement. Also in the course of judgment, any authoritative determination given pertaining to group of companies. So what they said finally, that once you feel that a joinder may be necessary in the circumstances case, please leave it to the tribunal. They are also judicially trained people. It's not necessary that they were former judges, district judges or high court judges or even Supreme Court judges. But they are supposed to apply their mind to the facts relevant to the point, whether a non-signatory should be included or not included. So leave it to the tribunal. This is about Cox and King. Let me take some of your time about Gayatri's judgment also now. Gayatri judgment 2025, decided on 30th April 2025, again by Constitutional Bench, Justice Sanjeev Khanna, CJ, as Lordships then was, is again doing a very yeoman service to the arbitration law. Section 34 was used both ways. To uphold the sanctity of the arbitral award, you could reject Section 34 because it lies in very narrow compass. But if you want to set aside the award, then the broad words like public policy, patent illegality, all these words could be fitted into the facts of the case and you could set aside the award also. Now the Supreme Court has very elaborately discussed all this concept, and this Gayatri Balasamy's case has said, sever the award. Find out the bad part. It's like cancer. If one organ of the body has cancer, what do? Don't kill the person. You remove that part of the body. So that is what the Supreme Court is trying to emphasize in this judgment. Remove the bad part. And before saying bad, pronounce upon it why it is bad. If you find that it's bad for established reasons in Section 34 and elsewhere, then only you sever that part. Modification, very, very limited. Like mathematical errors. Section 152 CPC, concept is that. So all these points which are being discussed in constitutional judgments now, I said at the beginning, are essentially common sense judgment. Because this law before these judgments was not very clear by different benches holding in different ways. The Constitutional Bench had to sit, spend their time, hear all elaborate arguments, and then said what could have been said much earlier also. The majority in Gayatri Balasamy's case gave 4 points. I'll just enumerate them, not take much of your time. because we are open to discussions further also. When the award is severable, the severing the invalid portion from the valid portion of the award is one thing which can be done in 34. By correcting any clerical, computational, typographical errors which appear erroneous on the face of record as well as other manifest errors, provided that such modifications does not necessitate a merit-based evaluation. You can't kill the soul of the award. You can sever the bad part of organ of the award. That is what the Supreme Court needs to say. By modifying post-award interest in some circumstances. Interest, we are in the era of international arbitrations also, where the interest rates are very different in different jurisdictions. So, dealing with such matters, if the court feels that it is not in harmony, because all arbitrators may not be knowing everything, and even the counsels may not put everything before them. So if that kind of offending part comes before them, this judgment now permits to sever that part, strike it off, and not necessarily send back the matter to the arbitration tribunal. By excess of powers under Article 142 of Constitution, albeit, the power must be exercised with great care and caution and within the limits of constitutional power. 142 only Supreme Court has. High courts do not have. This, to do complete justice in any of the case, the Honorable Supreme Court invokes 142, which of late with great respects has been invoked more frequently than perhaps necessary. But yes, in their wisdom, they thought that to do complete justice, it is necessary. And they invoked 142 in an income tax matter. Ashish Agarwal, if you recollect. So 142 is a very, very plenary power, and all plenary powers have to be exercised in discretion with a great amount of circumspection. The courts have to exercise that circumspection. So all this scenario of the two judgments, in my understanding, if I can say, are very good judgments. They have evolved, they have put the arbitration scenario on a very nice and stable pedestal now. And I think we all, arbitration tribunals now, and even councils, can draw their guidance from these judgments. And I think in times to come, even the Parliament may take cue from all these judgments. And I feel there are some areas where even the law will require amendment. And one such point which comes to my mind is Section 9. Interim relief before, during, and after the arbitration. I feel, friends, word during is wholly unnecessary. When you are dealing with arbitration tribunal, it can deal with Section 17 also. So the court to have a parallel jurisdiction in Section 9 during arbitration proceedings is, I think, a point which requires your debate and consideration, and it is unnecessary according to me. The other point I just want to make, because I have the podium, the appeals under Section 37, and a practical point, I am just telling you all this. When the former judges, maybe Supreme Court and High Court judges, have rendered some award or interim order, can a commercial court manned by a district judge should deal with that or not? I feel that requires a debate in the Parliament. And I feel the division bench, commercial division bench of High Court should deal where it's a reasonable classification. I don't want to say lesser designated arbitration tribunals are less competent. But then, practically speaking, I feel that this distinction can be made. Article 14 always permits reasonable classification. So this is what I wanted to tell you. Bullet points, not bullet-proofed, but then I leave it the podium to my other friends. Thank you so much.
A very good evening. With the kind permission of our Lordship, I may be permitted to present on the two judgments delivered by the Honorable Apex Court. Firstly, with regard to the Cox and Kings Limited, we all know that commercial transactions involve multiple entities, and in these transactions, the effect of non-signatory entity to the arbitration agreement was considered by our Apex Court in Cox and Kings judgment. While considering these aspects, the apex court has referred to previous position of law, which is broadly classified into two phases. Firstly, the pre-chlora control, and the second is the post-chlora control phase. In pre-chlora control phase, the Supreme Court construed the parties by limiting to the signatory to the arbitration agreement, and this is reflected in the judgment of Sukanya Holdings versus Jayesh H. Pandya, reported in 2003, 5 SEC 531. In summary, in pre-chlora control phase, the following three precepts was considered. One is that the arbitration could be invoked only between the parties, that is the signatory alone. And the second was the court adopted a strict interpretation of the provision of Section 8 before the amendment to the Section 8, wherein it referred reference to only to the parties, not otherwise, which the non-signatory as we called for. And the third was emphasized on a formal consent by the parties, and thereby excluding any scope of implied consent of the non-signatories to be bound by the arbitration agreement. In post-chlora control phase, this position underwent a significant change. In this matter, the court has allowed the joinder of non-signatory parties based on doctrine of group of companies. In this case, the apex court has reviewed the language of Section 45, which our lordship has said, held that expression any person reflects the legislative intent of enlarging the scope beyond parties who are signatory to the arbitration agreement to include non-signatories. The court accepted that the arbitration is possible between the signatory to an arbitration agreement and a third party or a non-signatory claiming through the party. And the court further expounded that the intention of the parties is the underlying principle for the application of group of doctrine, the group of companies of doctrine. Further, the court held that the non-signatory could be subjected to arbitration without their prior consent in exceptional cases based on four determinative factors, that is, a direct relationship to the party which is a signatory to the arbitration agreement, and the second, a direct commonality of the subject matter and the agreement between the parties being a composite transaction, and the third is the transaction being a composite nature where the performance of a mother agreement may not be feasible with the aid, execution, and the promise of supplementary or ancillary agreements for achieving the common object and collectively have a bearing on the dispute. And the last, the composite reference of such party will serve the ends of justice. The subsequent to post-chlora control, the Law Commission of India published a report in 2014 recommending amendments to the Arbitration Act, and the Commission observed that the phrase claiming through or under as used and understood in Section 45 of the Act is absent in the corresponding provision of Section 8 of the Act. And to cure this anomaly, it was suggested that the definition party under Section 21H be amended to include the expression a person claiming through or under such party, after which Section 8 was amended, wherein the party to an arbitration agreement or any person claiming through or under him could make a reference to the arbitration. And this led to the group of companies doctrine used in the context of the companies which are related to each other by virtue of their being a part of the same corporate group. The apex court has specified that to apply this group of companies doctrine, the tribunal or the court or the tribunal have to consider the following factors. That is, the mutual intent of the parties, the relationship of the non-signatory to a party which is a signatory to the agreement, the commonality of the subject matter, the composite nature of the transaction, and the performance of the contract. So with this Coxon judgment, the Supreme Court in its decision marks a significant affirmation of the group of companies doctrine within the Indian arbitration law. So this is with regard to Cox and King's judgment, where there's a clear the apex court has clearly marked a significant as to in what context the non-signatory could make binding with regard to the arbitration clause. The secondly, in regard to the judgment of Gayatri Balasamy is concerned, we all know that Section 34 of the Arbitration Conciliation Act governs the grounds for setting aside the award. And the said provision does not provide any power to the court to modify the award, except setting aside or confirm. Before I proceed further, I would like to refer to the Hakim's judgment, wherein the Honorable Apex Court has held that the court has no power to modify an award and observed. This is the quote which I'm taking it from the Hakim's judgment. Quite obviously, if one were to include the power to modify an award in Section 34, one would be crossing the Lakshmana Rekha and doing what, according to the justice of the case, ought to be done. In interpreting a statutory provision, a judge must put himself in the shoes of the Parliament and then ask whether the Parliament intended this result. The Parliament very clearly intended that no power of modification of an award exists in Section 34 of the Arbitration Conciliation Act 1996, and it is only for the Parliament to amend the aforesaid provision in the light of the experience of the court in working of the Arbitration Conciliation Act of 1996, bring it in line with the other legislation the world over. So it is clear in the reading from the observation that in Hakim's judgment, the court has held that the court has no power to modify an award. Prior to this decision, prior to the Hakim's judgment, there were other judgments where the court has taken a liberal view with regard to the limited interference and on the ground of miscarriage of justice. And in this background, I would like to refer to the present judgment, wherein the issue was raised before the Honorable Apex Court, which relates to whether to what extent the power of modified could be implied within the broader framework of judicial review under Section 34 of the Act, and could a statutory mandate to set aside an award be judicially interpreted to include a more limited intervention of modification, or would such interpretation amount to judicial overreach, impermissibly expanding a narrow statutory remedy under the guise of equitable justice? And in this background, the 5-judge bench has framed the following questions, which our Lordship has already gone into, so I will not repeat those aspects. But in this background, the Apex Court has examined both 1940 and 1996 Arbitration Act to determine the legislative intent and the jurisdictional limits imposed on the courts under Section 34. And it was thereafter concluded that although 1996 Act does not grant the power to modify or vary an arbitral award, explicitly a limited power to modify was impliedly made applicable to the courts. And this implied power ascends from the need to ensure some judicial insight to prevent unnecessary hardship, delay, and expense in the arbitration proceedings. The majority opinion in this case represents a significant shift in the arbitration law of jurisprudence, arbitration law jurisprudence, articulating authoritatively a limited judicial power to modify an arbitral award under Section 34 does exist. So, especially in Gayatri Balasubram case, because we as a trial court judges, because I am a trial court judge, we used to always have that difficulty. Whenever a matter come before us under Section 34, we used to always see because the jurisdiction itself was very limited, we only have to see whether the award of an arbitrator is correct, is proper or not, except that we do not have any interference was been very limited. So when Hakim's judgments came, many of, especially we as a commercial court judge, had an issue, because whenever there was an argument addressed by the advocates with regard to the ground urged or the ground made out by the, whenever there's a claim by the advocates that the arbitrator exceeded the jurisdiction or the award passed by an arbitrator is not correct, we did not have any jurisdiction to either set aside either in portion. But all that we have to do is set aside in entirety or confirm it. So this difficulty we had faced, and in such cases, especially the judges, we could not do anything much because of the Hakim's judgment. But now I feel that, especially with the Gayatri Balasubram judgment, we as a trial court judges, we have a little bit of scope. The limited interference has been provided, and we can exercise that limited jurisdiction. And this judgment is going to be helpful for us. So with this, I would like to conclude and I would like to conclude and hope the necessary insight provided to the problem faced by the dealing with the non-signatory and the modification of award in the present judgment is going to be helpful for all of you. And I thank the Karnataka Judicial Academy, Dr. Radha Madam, and also the Arbitration Center, Egde sir, and Alok sir, and Vignesh, for all of you for listening patiently. Thank you.
Honorable Justice Magdam, Honorable Justice Vineet Kothari, Bhavani ma'am, my friend Shamir, ladies and gentlemen. Unlike the previous session, which was a panel discussion, this is a lecture session. Now, the difference between a panel discussion and a lecture session is that in a panel discussion, sometimes you don't have the opportunity to reach out to the last person in the audience. We just had until now Mr. Gaurav Pachnanda sitting here, senior counsel from Delhi, who is almost the face of India's arbitration before the international arbitration bodies. And we have students of law sitting here from this city. So the audience is in divergence. The level of understanding of the audience of the two judgments that we are discussing definitely cannot be the same. And if it were to be a panel discussion, there wouldn't have been an opportunity to actually, in a lecture manner, which is why we intended this to be a lecture series, but that's why everybody is coming onto the podium and speaking, to decode these judgments to the audience. So therefore, let me take this as an opportunity, and for those, and with an apology to those who very well know these judgments, it may sound a little patronizing, but for those who are not in complete grip of these judgments, let me try to be a little helpful. So let me see the last person in the audience in mind and try and tell you what these two judgments are about. Law, as we understand, is a dynamic subject. Every area of law is a dynamic subject. But the most dynamic subject within law is the law of arbitration. Every day, arbitration proves that it is a subject in progress. It is work in progress. And these two judgments eminently exemplify this principle that arbitration law is constantly a work in progress. I am a little constrained while explaining Cox and Kings because the law firm that I work for has represented one of the parties there in the Supreme Court. And as our firm policy says, once we appear in a matter, we don't publicly critique that judgment. Of course, an academic analysis is possible, but beyond that, we don't pass opinions on it in writing or on public podiums. But I will definitely deal in an academic sense with what Cox and King really says for the benefit of the last person in the audience. Then I will, of course, go to Gayatri Balasamy. I'll take a slightly different approach. I'll leave you with about 8 questions that I have formulated for your thoughts. And if we have time, we can further deliberate in the discussion with the audience, these 8 questions and beyond. So therefore, Cox and Kings is about joinder of parties. What is an arbitration? An arbitration is where two people sidestep from the public court and they say, we do not want a public platform. They get into closed door business of adjudicating their dispute in a private manner. In fact, the latest judgment of Supreme Court says a third party can't even be an observer in an arbitration proceeding because, and confidentiality clause is specifically written in the Arbitration Act. Therefore, an arbitration is not only a private proceeding, it's also a confidential proceeding. That being the case, can you have a joinder of a party who has not signed the arbitration agreement? That's at the heart of Cox and King. When you look at it, when you look at the jurisprudence on this, you will see India has gone absolutely zigzag on it. The first relevant judgment is Sukanya Holdings. Sukanya Holdings says that if in a matter, some parties are parties to arbitration, the other parties are not parties to arbitration, then everybody will have to go to the civil court, notwithstanding the fact that some of them are bound by arbitration. Because there are parties who are not parties to arbitration agreement, the suit cannot be split into one arbitration and the remaining suit, and the non-signatories cannot be sent en bloc to the arbitration. Rather, everybody will go en bloc to the suit. That was the first position that India had, and that is Sukanya Holdings. diagonally opposite to Sukanya Holdings, Chloro Control comes and says that because Section 45 of the Arbitration Act uses the expression any party through or under. Firstly, any party is a large expression. It's further qualified and circumscribed by through or under a party who has signed the agreement. But even despite that circumspection, any party claiming through or under is wide enough to say that group of companies can come together in an arbitration even if only one of such companies within the group has signed the arbitration agreement. And the inference there made is that within a group company, if one party has signed the arbitration agreement, within the group companies, they would only have meant well for each other. Therefore, the party who has not signed the arbitration agreement cannot be hurt by the arbitration agreement signed by one of them. And therefore, everybody, as long as they are a group of companies, as long as the transaction is composite in nature. So two principles. One is the entity is group. Two is the transaction in question is composite. Let's say there is a principal loan agreement, there is an ancillary mortgage agreement. The transactions are joint. One of them has arbitration, the other does not have arbitration. Chloro says if one is executed by one within the group, the other is executed by another within the group, notwithstanding the fact that one does not have arbitration clause, everybody can together be sent to arbitration and nobody's objection can be therefore looked into. So that's opposite, diagonally opposite to Sukanya Holdings. From Chloro, India travels back to doubting Chloro in the first Cox and Kings. That's the 3-bench judgment in Cox and Kings, where Justice Ramana, the then Chief Justice, says that what are we talking about? We are talking about some economic principles. But we need to pass it through the needle of law. And the only needle of law, economic principle is a matter of convenience. Does the law recognize this principle? The only law that you have said in Cox and Kings is there is a through or under language in 45. That does not seem to be deliberated enough. And therefore, we doubt it. We are not setting it aside. We doubt it. We refer to the larger bench. So from Sukanya, you have traveled diagonally opposite to Chloro. From Chloro, you have again come back to the other end of the spectrum, doubting it. And that doubting it further comes to now the present Chloro, which is the 5-judge bench in, present Cox and Kings, which is a 5-judge bench in Cox and King, where in a very maverick way, in a very clever way, Justice Chandrachud, and I understand that there are a lot of members of district judiciary present here, the manner in which judgment writing, the engineering of judgment writing, as I put it, can be learned from this, from the way in which Chloro has dealt with the subject. I'm so sorry, Cox and King 5 judges bench, speaking through Justice Chandrachud, has dealt with the subject. What he says is, look, I have no doubt that Chloro has laid down the right principle and group of companies can be together sent to arbitration. But not because Section 45 then and thereafter through parliamentary amendment, Section 8 now says through or under. Group of company principles is a well-established principle of corporate law. It is not coming from through or under language or the Arbitration Act. In our general contract law, in our general commercial law, in our general law of commerce, group of company is a well-established principle. Therefore, dehost the Arbitration Act, group of company principle has to be recognized. So it agrees with Chloro, but not for the reason that Chloro has said what it has said. And then he says, now he has to overcome a few hurdles. That's why I'm saying maverick judgment writing. So he has to look at how to bring in a non-signatory to an arbitration. In a very passing way, somewhere in the judgment, in the beginning of the judgment, he says, well, I'm not discussing third parties, I'm discussing non-signatories. When you read the judgment, you will almost miss that paragraph. But when you go back to that paragraph, you will know that is the crux of the judgment. A third party is by definition a third party to the contract. But a non-signatory is a party to the contract, just that he has not signed the contract. But he does not explain it. He simply says, I'm just not using the word third party, I'm just using the word non-signatory. then he has to come to the question as to how a non-signatory can be brought within a contract. Now, there is a non-signatory, there is a contract. How do you bring a non-signatory within a contract? So all of us would have then addressed the question as to who is a non-signatory. He does not do that. He says, I will address what is a contract. He says a contract under the Contract Act is not merely a written contract, it is also an implied contract. Now look at the beautiful way in which the jurisprudence is developed. So here is a non-signatory. He has to be brought within the contract. Instead of forcing him into the contract, I will expand the definition of the contract, because contract under the Contract Act is also implied contract. He then has to encounter a question, but then Arbitration Act says under Section 7 that there needs to be a written agreement. What do you do? He very carefully breaks down Section 7. He imagines an imaginary line in the middle of Section 7, and he says that Section 7, after all, deals with a contract. A contract, by definition, also includes implied contract. Where it says it has to be in writing is a formal part. So there is a substantive part, there is a formal part. Substantive part cannot be curtailed by the formal part. The substantive part says that a contract has to be entered into. A formal part says that it has to be a signed contract. As long as two parties sign it and there is a contract, there is a contract. But if there is a non-signatory who is otherwise bound by this contract, then he is also a party to the contract, though he has not signed the contract. This is what I call maverick judgment writing. Thereafter, he specifically comes to the issue as to whether how should the group of company principle be entertained. He says that, well, group of company is not traceable to the Arbitration Act. It is to be traced to our general understanding of contract law, commercial law, Companies Act. Group of company is a very well-established principle. But he almost removes group of company as a matter of status and makes it a matter of conduct and intention. And he says that group of company can be either forcefully judicially inferred. For instance, piercing corporate veil. That is where the judge forcefully pierces the corporate veil and finds out the group of company. That will not apply here in arbitration. Arbitration is consensual. So therefore, judge will take a step back. You look at the conduct of the parties. If the parties by conduct have done the needful to show compositeness in transaction, if the parties have together been participating in the drawing up of the subject contract, if the parties are meant to perform that contract together, so I am not forcefully piercing open any corporate veil, but mere looking at the conduct of the parties, if I can infer that they meant to bind themselves, then in a consensual way, I can say group of companies. So group of companies is now freed from status and it has been brought to an arena of conduct. In that sense, he says, therefore, in those cases where group of companies can be inferred by the conduct of parties, and he says chloro has to be very carefully seen. I don't think, and he disagrees that it has to be traceable to the through or under language in the Arbitration Act. After chloro had come a judgment called Rekit Benkisser, in which the court had said if a party has participated in the arbitration, in the drawing up of the contract, let's say director of a subsidiary company had participated when the principal agreement was being negotiated between the two parties. That is involvement of the non-signatory in the preparation of the contract. He says preparation of the contract involvement is a valid consideration, but it is not an incidental preparation. It has to be a substantial participation in the preparation of the contract. Similarly, performance of the contract, he says there has to be a substantial performance that this non-signatory should do in the performance of this contract. There should be a substantial involvement. If all these tests are satisfied, then he says group of company principle is very well established and it need not be doubted. Like in Cox and King 1, the court had doubted. Therefore, today that's the spectrum where we are in. We started from Sukanya, went to chloro, came back to Cox and King 1, and then came back to Cox and King 2. So between Sukanya and Cox and King, we need to find our answers. The question that I'm going to leave you with is, do you think that Cox and King 2 has come and substituted Sukanya, or do you think that Sukanya still is a good law and Cox and King is an exception? I would go with the latter. Because it's like saying that each company is an independent entity. In required matters, we can lift the corporate veil and find who has joined hands with whom. In that sense, most people today may mistake that Sukanya's age has gone. After Chloro, Sukanya is irrelevant. I would disagree respectfully, and I'll say Sukanya is still the good law. If there are some parties to the matter who are bound by arbitration, some parties are not, the principal approach must be that everybody has to be sent to a civil court. But if the parties who have not signed are group of companies and they are bound by each other in the manner in which, and that's important, only in the manner in which Cox and King has subscribed it, then of course as an exception to Sukanya, Cox and King stands. Therefore, Sukanya hasn't gone away. My understanding is Sukanya hasn't gone away. Sukanya stands, Cox and King stands. The latter is an exception to the former, and all our answers will have to be found in this spectrum between one and the other. That's my analysis of Cox and King. Now, Gayatri, 1940 Arbitration Act had a specific provision, Section 15, that said that if a Section 34 court is not happy on certain limited grounds with an arbitral award, he can modify. In fact, the subsection itself started, the subheading itself is modification. He can modify. Now, 1936 Act says set aside. So 1940 Act, the 34 court could have modified it. 1936 Act, there is no power of modification, you can set aside. So the question is, after setting aside, do you again send it back to the same tribunal? There Gayatri says that's highly unjust. A party has arbitrated so long. After that, in Section 34, if it has to be set aside and again sent back, then it is injustice. The approach adopted by the majority is, as long as there is no prohibition in the language, it is permitted to modify. The approach adopted by the minority, namely Justice Vishwanathan in the judgment, is that as long as there is no permissibility, you cannot do it. So 1940 Act permitted it, 1996 Act does not permit it, so you cannot modify. Majority says no, 1996 Act does not say you cannot modify, therefore we will infer the power of modification. And this has rifted the bar and divided it into two. Pro-arbitration people are supporting the minority, saying a judge can't decide in the first place. We wanted the arbitrator to decide, so a judge can't substitute. And therefore, this judgment is criticized for its majority view. And the minority view says justice has to prevail. You can't send it back after so many years. And therefore, the court has to decide. I have about 8 questions, but I'm told that my time is out. If there is further time for interaction with the audience, I will lay down my 8 questions. This is my very, very brief introduction of these 2 judgments. I hope it is of some use. Thank you very much.
Honorable judges on and off the dais, seniors, and dear friends. Let me start with a bit of a confession before I get into the meat of the topic itself. In my own naivety, when I was preparing for speaking on this topic, I thought the best position that I could possibly take is to take a dissenting view on the effect of Gayatri Balasamy and try to attempt to criticize it. And now here I stand before you, having done a terrible job of reading the room, where everyone feels that Gayatri Balasamy basically brings in the much needed change. And second, I think my friend there already put up a placard to say 1 hour is already up and therefore we'll need to conclude quickly. So I think put 1 and 2 together, I stand here before you under tremendous pressure to finish quickly and rush for the exit. Now, with that, I think for the purposes of this discussion, I wanted to focus specifically on Gayatri Balasamy because enough has already been said on Cox and Kings. And within the context of Gayatri Balasamy, one particular aspect of that judgment, which deals with the power of a Section 34 and a Section 37 court to remand the matter back to the arbitral tribunal for a redetermination on certain limited aspects. I think that one aspect throws up some very interesting questions, and before I get into those questions, let me present a scenario here and also throw into this mix two other judgments which I feel are relevant. One is, let us start with Vidyadrolya in the year 2020, which lays down this principle of when in doubt, refer. After that comes the decision in Cox and Kings, which essentially recognizes this position of making a non-signatory party a party to an arbitration and making the reference, and within that context also only making a prima facie determination of whether the non-signatory party can be bound by that arbitration agreement, and leaving the meat of whether such a non-signatory party is at all liable in terms of the final award that the arbitral tribunal will pass to be determined by the arbitral tribunal. Add to this mix the decision of the Supreme Court in interplay between arbitration agreements and the Stamp Act, which also says issues of insufficiency of stamp duty also have to be determined by the arbitral tribunal. Now, in this background, let me give a quick scenario. I initiate an arbitration against a subsidiary entity, and in that arbitration, in a Section 11 petition, try to also array the parent entity. And let me which is the scenario that most of us also face. The arbitration agreement on the basis of which I'm doing this is also insufficiently stamped. But thanks to the first three judgments, effectively what it means that this matter will stand referred to an arbitral tribunal to be determined on merits. Now, the arbitral tribunal in the end, in the ultimate determination, effectively takes the view that there is no case to be made out to impose liability on the parent, and therefore imposes liability only on the subsidiary and passes an award. And now this is ultimately challenged in a Section 34 proceeding. In such proceeding, having regard to Gayatri Balasamy, what the arbitral tribunal, what the Section 34 court can now effectively do is remand only the issue of whether that non-signatory is to be bound by the arbitral award back to the arbitral tribunal. And now in this context, I think now let's just work with this picture in mind, which is we have concluded one leg of the arbitration. The arbitration is remanded back to the arbitral tribunal for a fresh determination on this limited aspect of the liability of the parent entity under the arbitral award. Now, I think in this one, the very first problem which we as practitioners are going to face in this scenario is an arbitration originally instituted has strict timelines for completion of pleadings and also the time period within which an arbitral tribunal has to pass an award. Therefore, the first question is, what is the timeline that an arbitral tribunal which is looking into the matter after remand is going to follow? There's no clarity. Second, now, one possible way of maybe solving this problem is getting the Section 34 or the Section 37 court to expressly state that the arbitration in the second rung will be decided, let us say, within 6 months. Now, with that comes the second leg of the problem, which is if that arbitral tribunal does not make the determination within that stipulated period of 6 months, does it mean that the mandate of the arbitral tribunal has expired, therefore necessitating an extension under 29A, or does it mean if it is an order of remand by a Section 34 court, I go back to that Section 34 court and get an extension of timeline, or in the event it's a remand by a Section 37 court, do I therefore go to a Section 34 court or a Section 37 court for the purposes of that extension? Again, much clarity is required. Now, another troubling aspect of this aspect of remand under Gayatri Balasamy is for correction of any computational or clerical errors under Section 33, the time period stipulated is 30 days. Now, a party which does not choose to file that application within 30 days, thanks to Gayatri Balasamy, now has a second opportunity to file that application within 120 days before a Section 34 court and push for the very same corrections. Two other problems which I was able to identify if the remand portion of Gayatri Balasamy were to be put into practice is once an award in the second round of arbitration is passed, and let us say this award was by a Section 37 court, the appeal that has to be filed against such an award, would that be filed now, therefore, before a Section 34 court or before a Section 37 court is also a pertinent question. And two other issues here. One is with enforcement. Now, in my own scenario, the arbitral tribunal effectively found the subsidiary liable and the parent not liable. So for all practical purposes, you have in your hands an award that can be enforced against a subsidiary, but not the parent. Now, while that challenge by the parent before the Section 34 court is pending, and there is no stay on the arbitral award, what will be the executability of such an award which is passed against a subsidiary is also a huge question mark. Does it automatically mean that you can continue enforcing the award against a subsidiary, but you can only not enforce against the parent is again something we do not know. The last aspect, the last trouble, so to speak, that comes up because of the remand portion of Gayatri Balasamy is we all know Section 32, if I'm not mistaken, states that the mandate of the arbitral tribunal terminates effectively once the award is passed. Now, given that Gayatri Balasamy gives Section 34 and Section 37 courts the power to remand an arbitration back for redetermination by the arbitral tribunal, does it now mean, therefore, that until the Section 34 and the Section 37 leg of the proceedings is concluded, the mandate of the arbitral tribunal, therefore, should be deemed to extend? Now, having said all of this, to my mind, I think there is one possible solution that we can explore, which is, of course, in the context of the 2024 Arbitration and Conciliation Amendment Bill, which surprisingly under Section 34 still does not include a power to modify arbitral awards. One possible solution could be to just introduce all of this legislatively into the Arbitration Conciliation Act so that some of these anomalies, starting from timelines to the impact on parallel proceedings, can be adequately addressed, and this is not without basis. Gayatri Balasamy, in the judgment itself, discusses the law in other jurisdictions where statutorily the power not only to modify but also to remand is recognized. Case in point, I think what I would like to highlight is Section 11 of the Federal Arbitration Act in the USA. This provision does not include the power to remit a matter back to the arbitral tribunal, but what it does include is the power for a challenge court to essentially fix any minor issues with an arbitral award which would otherwise result in the award being set aside. So therefore, maybe one possible way of resolving this issue is to limit the scope of power of a Section 34 court, not only to setting aside, but to modification on some minor aspects. Now, the last point, maybe I'll just take a minute to conclude this, and this sort of ties into what Prashant was saying right towards the end, in terms of Cox and Kings and how it's gone from one point to the other, and whether Sukanya Holdings continues to be good law. The answer there, I feel, is in the 246th Law Commission report, which was essentially the report that led to the amendments to the Arbitration Conciliation Act in the year 2015, and specifically the insertion of the language in Section 8, which said a Section 8 court essentially has to restrict its determination to the prima facie existence or otherwise of a valid arbitration agreement. Now, what was in the Law Commission report was also a suggestion to remedy one problem. And I think most of the practitioners here in the audience, and perhaps the judges also, can relate to this. There will be suits filed before a civil court where a plaintiff with the sole objective of defeating an arbitration clause would maybe array 4 or 5 other parties to that suit who are not parties to the arbitration agreement and effectively argue that the dispute is not covered by the arbitration agreement. What the Law Commission said was two things. One, that the issue that Sukanya Holdings has identified needs to be remedied. And second, introduction of a proper and necessary party test into Section 8 of the Arbitration Conciliation Act to say that a Section 8 court would refuse reference only where it finds that those non-signatory or non-third party entities to the suit are proper and necessary parties to the suit. That is the only situation in which the civil court would essentially choose to continue the suit rather than make the reference of the matter to arbitration. Now, to just sum up very quickly and without taking too much of any of your time. So, Gayatri Balasamy, in sum and substance, is of course a welcome development. Power of a Section 34 court to modify awards where there are some minor issues with that award which would make it enforceable is more than welcome. But the portion on remand of the arbitral awards is definitely going to be problematic in the near future, and I think all of us are going to see a lot of litigation in that context unless the legislature were to step in and bring in some most needed amendments. Thank you so much.
I think Prashant and Mohammad Shamir really took you to a different level. a greater insight was given by Prashant and Shamir. His Lordship Kothari Saab uh, played a crucial role in opening up. Probably the address by Prashant and Shamir might have created some confusion in your mind, so you can ask questions to those two. Yeah. Any questions from the audience? Yes, sir. Yes, sir. You can ask to two extreme ends.
Of course, that situation has not yet arisen before me in the arbitration proceedings. An arbitration agreement shall not be discharged by the death of any party thereto, either as respects the deceased or as regards any other party, but shall in any such event be enforceable by or against the legal representative of the deceased. Supposing in the event, during the pendency of the arbitration proceedings before the arbitrator, if either the claimant or the respondent dies, can we proceed with the proceedings as against their legal representatives? But shall in any event be enforceable by or against, that is, that agreement can be enforced against. That's all. Should there be a formal...
It can be enforced and it will be against the asset.
Yes, yes.
Just
as in CPC section.
Yes, yes. The estate of the deceased. Deceased.
That's all. Thank you. I thought it has some relation to this, therefore.
So succession is statutorily recognized in the Arbitration Act.
Yes, yes.
Because the parties have passed away, the arbitration does not stop. Succession is statutorily laid down.
There's also an exception there. If it is activa personalis marked as some persona, then it would not apply. Subsection 3 also clarifies. Thank you.
Thank you for entertaining me and giving me an opportunity to ask a question. So my just short question is, whether in a Section 9 petition in an arbitration, whether the court then has the opportunity to decide whether a third party, not a non-signatory, but a third party, to entertain an interim relief against them. And how would one go forward with that?
That is more liberally entertained. That's a very well-established principle that in Section 9 you can rope in third parties. That's more liberally entertained. For instance, let's say there is a dispute on refund of security deposit after the lessee vacates the property of the lessor. The lessor has given the property to another party. That other party is depositing rent with the lessor. You can rope him into Section 9 and file a proceeding and can have that money made over to the court. That's a very well recognized principle that in Section 9 you can have third parties.
Thank you so much.
So I had a follow-up question for Shamir based on what Sir just asked. Because you specifically brought up the issue that Gayatri Balasamy is very unclear with respect to remand and how long a mandate of the arbitral tribunal can continue, either after 34 or 37 remand. What happens in an instance where there is a death of a party or any other situation that should abate an arbitration agreement, but by virtue of Section 40 it is saved, but do you then see a situation where you can read in Gayatri Balasamy and say that it continues perpetually until all the appeal stages are closed?
You've raised an interesting question. This is something I could not touch upon while I was speaking because of we're running out of time. I will add to your question and then try to answer your question. The other side of the coin is, let's say at the stage when a Section 34 or 37 court is remanding the arbitration, the arbitrator either refuses to act or for whatever reason is no longer available to act. What do you do in that situation? Now, to my mind, the only solution I can find, which is what happens even now when arbitrators have to be replaced, is you file a petition under Section 11 before a high court and essentially get an arbitrator appointed. So that's the closest solution I could think of.
Any further questions? Thank you. I had all good intentions to thank each speaker separately while referring to their insights, but I know I'm standing between everyone here and their Saturday evening, so I will not do that. With everyone's permission, I will collectively thank our dignitaries on the dais for taking out time to be here today, for sharing their insights, and collectively for an excellent insight into both judgments, Gayatri Balasamy and Cox and Kings. I now request Mr. Harish Narsappa to present our speakers with a token of our thanks. May I request Mr. Sriranga to kindly come up on the stage? Please present our speakers with a token of our thanks.
Very, thank you so much.
We have come to the end of day 2 of Bengaluru ADR Week 2025. We thank you for spending your Saturday at this event and look forward to seeing you tomorrow. We begin at 10 a.m. For today, tea is served on the first floor. Thank you once again. Please rise as our dignitaries make their way out of the auditorium.